how one applies for asylum? What are the procedures for applying for asylum? Now, first, it has to be noted that there are two different types of asylum application. One is called affirmative, and one is defensive. The difference between those two types of asylum application or asylum process is that affirmative application is when you are applying for asylum without being in the process of removal or deportation from the United States. That means it's typically the case when someone enters the United States on a tourist visa or any other type of non-immigrant visa, and they have basis for applying for asylum. So they decide, they find out what needs to be done, they hire a lawyer or not, and then they prepare the applications and file with the asylum office, where they're affirmatively asking for the protection of the United States government. The defensive asylum application is when the United States government is trying to remove or deport this individual from the United States because they're out of status or they're unlawfully present in the United States. And the applicant says, wait, I can't go back home because I will be persecuted for various reasons, one of those 5 bases for asylum. And that's called defensive asylum application. So let's first start with affirmative asylum application. What are the procedures for that? As it's known, the asylum application has to be filed within the 1 year of the presence in the United States. So the way the procedure is that the asylum applicant must prepare an application for asylum. It's Form I-589. And attached to it, the asylum applicant must submit to the United States Citizenship and Immigration Service a statement or a declaration by the applicant describing why he or she is applying for asylum and why the applicant is eligible for asylum. And then you must include and attach any documents and evidence that subjectively or objectively demonstrate that you are eligible for asylum, plus that the documents, the evidence that supports your case, that supports whatever you are saying in your asylum application or in your asylum declaration, as well as the country conditions describing your home country from which you fear the persecution, and the State Department reports, any other news reports or documents demonstrating that supporting your asylum case. Now, the asylum application is filed with the USCIS. It all gets mailed together and filed. There are 3 copies of the entire package that need to be filed for each applicant. And the United States Immigration Service receives the application, then they process it, goes through normal processing channels, and then according to regulations, the USCIS, the asylum office, must schedule an asylum interview within 45 days after the receipt of your application package, and they must make the decision within 2 weeks. However, in practice, lately that hasn't been the case because of the substantial backlogs in the asylum office, because of the delays in the asylum cases. Currently, it may take anywhere between 6 months to 1 or 2 years until the USCIS asylum office is able to schedule an interview of the applicant. At the interview, the applicant will be able to explain the reasons to the immigration officer why he or she is eligible for asylum. The officer will ask questions and inquire to verify if first the applicant, if everything in the applicant's story or asylum application is true. The asylum officer will verify if the applicant's story is credible, if the applicant's testimony is credible. And the second, the asylum officer will verify if the applicant's story is credible and everything is true, whether the applicant qualifies for asylum based on the story. And the officer will make the determination. If the asylum applicant is in the United States out of status at the time of the interview, the decision will be made, and is typically made within 2 weeks, and the applicant is asked to return to the USCIS asylum office to pick up the decision. Or if the applicant is still in status, in a valid non-immigrant status in the United States, then the decision most likely will be mailed to the applicant. Now, if the asylum applicant is out of status, doesn't have a valid status, there are two decisions that can be made. One is the grant of asylum, and if the applicant is granted asylum, or he and his family will all be granted asylum, immediate family will be granted asylum together, and then they can remain in the U.S., work, live, and enjoy the privileges, and then 1 year after the grant of asylum and physical presence in the U.S., they can apply for permanent residence and then eventually citizenship several years later. If the asylum officer does not believe that the applicant is eligible for asylum for one or several reasons, then the officer must refer the case to the immigration court, to the immigration judge to consider the case, and the applicant will be given a second chance to be able to prove that he or she is eligible for asylum. Now, as I said, the process in the asylum office used to take much shorter time, which usually used to be 2 or 3 months. Now it takes at times a year or two. Then when the case goes to the immigration court, again, it may take several years until the applicant's case is heard by the immigration judge in the court proceedings, where the applicant will have to demonstrate to the immigration judge that he or she is eligible for asylum. Now, what if the immigration judge denies the case? Well, if the judge denies the case, then the applicant is ordered removed from the United States unless he or she applies for voluntary departure or other form of relief. And the applicant has a right to apply for appeal with the Board of Immigration Appeals. The Board of Immigration Appeals reviews the case of the decision of the immigration judge and determines whether there was an error in the decision of immigration judge, or if there are any substantially changed circumstances that weren't present at the time of the individual hearing in the immigration court that warrant now approval of the asylum application of the applicant. If the Board of Immigration Appeals denies the case and affirms the decision of the immigration judge, then the case can go to the appeal to the next level, to the federal court, circuit court appeal, which would also last currently, based on the current timing, about a year or two, or sometimes more. And then eventually, if the federal circuit denies the case, then the applicant has a right to appeal, and the case can go up to the United States Supreme Court if the Supreme Court grants certiorari, which means that if the Supreme Court decides that this is a case that is worth for them to review and make decision, to render a decision on. Now, if the asylum application is filed defensively in the immigration court, in the removal or deportation proceedings, this means that the asylum applicant wouldn't have a chance to prove it to the immigration officer through the immigration office. He or she will only have one shot at it with the immigration court, and there goes all the rights to appeal thereafter if the case is not granted. Now, there is a misperception that the applicant really has two chances, can apply through asylum office, and then if it doesn't work out, then it can apply through immigration court. It's not that easy. I mean, if the asylum office denies the case, well, let me put it this way: the asylum applicant has the best chance and the quickest chance to get asylum affirmatively through asylum office. That's why the entire focus must be made on proving your case through asylum office affirmatively rather than through immigration court. The reason being, again, the timing, because during the period while waiting for the decision, while waiting for the court hearings or interviews, the applicant doesn't have any status. He or she is just an asylum applicant, and they can remain in the U.S., and unless they caused any delays in the procedures, they will be entitled to work permit. They will be able to live in the U.S. and work. However, they won't be able to sponsor relatives. They won't be able to bring their relatives from overseas, their family members, and they won't be able to also depart unless they have emergency or extraordinary circumstances, they won't be able to leave the United States and then return during the pendency of their case. So that's why the entire focus must be made on trying to prove your case and to get approval of your case, asylum case, through asylum office, through the first step of the affirmative process. Other important notes in the procedure for asylum case is that submitting evidence, submitting timely evidence, the entire package, including the evidence, country condition reports, and your application and statement must be submitted at the same time with the asylum office. You can supplement this before the interview. Different asylum offices have their own rules, but it's usually 10 days at least before the interview. If you have any additional documents that you would like to submit before the interview, and you can also submit more documents if you fail to get asylum through the interview, through the asylum office. You can submit more documents before the immigration court hearing, the final hearing, at least 15 days, unless the judge orders otherwise. But again, it's very important to submit, to try to focus and to submit everything in the beginning, and to be able to do so, to gather all the evidence, to prepare your application, to be ready for proving your asylum case within the first year of your presence in the United States. So this is the basic procedure. Of course, there are a lot more details that we can discuss, but this is the procedure, a big picture of the asylum application process.